Hi, I'm James.
And I'm Anthony. This Saturday bonus episode is a recording of an interview we gave on another podcast. Regular Words and Numbers episodes come out each Wednesday.
Welcome back. I think we're going to have to take care to think about something that nice people tend not to talk about in public. I want to talk about abortion rights as they've unfolded in the United States as a proxy of sorts for rights more generally. So understand that I don't want to get into a debate about abortion. I'm sure none of you do either. However, there are some things that when we look at these things through this lens particularly, things get really interesting. So let's use this as a tool to understand larger issues and trends in the United States. And let's just kind of ignore the hot button nature of the topic itself. And I think we can do that if we approach it with a certain openness of mind and a certain charity towards one another. Because really, if you think about it, when we end up talking about things like gender and/or sex and the law, boy, that's a big pile of stuff to talk about. And finding something that we can all at least understand reasonably intuitively is kind of tough. But we all know about Roe versus Wade. You know that in the early 1970s, this was the case that eventually, as it worked its way through the court, yielded out a condition under which women were able to seek, find, and engage people in order to get to abort their pregnancies. So we all know about Roe versus Wade, but the obvious question to ask is how much do we actually know? And you should be at least dimly aware that there's probably a lot more to it than you hear when we start debating this thing nationally. And we almost inevitably debate this nationally when and only when it's time to nominate a new Supreme Court justice. So, all right, at least leave open the possibility that we might not know what Roe versus Wade did or even is. Now, the Supreme Court of the United States affirmed a woman's right to an abortion in this case. But how? How did it do so? And here's where it gets a little interesting because we're back again to the post-Civil War amendments. And this time the 14th Amendment, which was the amendment that meant to extend civil rights to freed slaves. But again, as was the case with the 15th Amendment that we discussed last time, it was written in such a way to include everybody in the country, right? It's not specifically only about freed slaves. It's not even specifically about black people. And there were more black people than there were freed slaves, right? So you've got a number of things swimming just below the surface here. But here's the text of the 14th Amendment that matters. It's not the whole of the text, but it's the important bit. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, if I were to ask you, what part of that would somehow yield increased abortion rights for women across the country? I don't know that you'd be able to look at that and figure it out. I know I couldn't. So we're going to have to deal with what the Supreme Court actually says about these things. And in this instance, this is the part that the Supreme Court would point you to, that due process was violated by states that disallowed abortion as a matter of course. There were any number of states that disallowed abortion as a matter of course. One of which should probably come as no surprise to you was Texas, where this case was heard. So the question that presents itself early was Jane Roe. That was the name used to hide the name of Norma McCorvey, who was Roe and came out later in a couple of different times in order to grind a political axe. People were only too interested in letting her do that. Was she denied her due process rights in the state of Texas when she was told as a matter of law that abortion would not be available to her? She was fighting a state law that was duly and correctly passed in Texas. Now, the question was were her due process rights violated? Well, what's due process becomes the sort of question that you've got to ask here. And due process, for most of the history of this country, meant simply that the issue under consideration, regardless of what it is, was it addressed by a legally sitting legislative authority following set rules? Now, when Texas declared that there would be no abortion within its borders, clearly that's a state law. It's duly passed according to the rules of Texas. This should have been sufficient to prove her claim incorrect. Also consider this. By the time that Roe was decided, the 14th Amendment had been in effect for 105 years. If the correct constitutional lens for the case is this, why did it take over a century for people to realize that? And that's an open question. So, what do we think about this? Due process doesn't seem at all to be the right way to see this case. One of the justices brought up the Ninth Amendment, which was an interesting one, where federal law, might have to yield to state law, and there's all these kinds of considerations going on under the surface. But why due process? And you get the same answer here that you're going to get in any number of other cases. It's very similar to what we saw in the Brown case. Remember that Brown was decided on amendment grounds, only to find in Bowling versus Sharp that when you look at the 14th Amendment, it says no state shall. That doesn't apply to D.C. So we're going to have to come up with a new theory for D.C. Well, so too, in a lot of ways, and you get this very clearly in the Hollow Hope. And I'll have something to add personally on this note in a moment. You start to see that the tide had shifted in the country's understanding of abortion law. It had gotten to the point where most of the country actually had moved to a place where they favored at least some abortion rights for women that would be beyond the reach of any political body. And I think O'Brien does a nice job of tracing out just how much that was the case. And I knew this was the case before I read the book. When I was a very young boy, I had an aunt, her name was Louise, and Aunt Louise lived to be 100 years old. So she would occasionally tell us stories when we went over to her house for dinner or to play cards the way we did when I was young. She would tell us stories about World War I and the Great Depression, which just seemed so long ago, and yet she had lived through them. She had very keen memories of the Depression and much more keen when it got to World War II. But Aunt Louise's house was very, very strange. It was in Waterbury, Connecticut, where I grew up. And every bedroom in Louise's house, and there were 4 up and down the upstairs hallways, every bedroom had a very significant lock on the door, which is odd. If you think about your bedrooms in your homes, you rarely have locks on bedroom doors, maybe a little more in the last 10, 15 years, but that was always a bit of an oddity. And then if you went downstairs at Louise's house, you found a long rectangular room with a bar in the front of the room and a big blank piece of wall. And it turns out that her house, which she bought in the late 1940s, early 50s, her house was actually an abortion clinic. And in the bedrooms upstairs, that's where the abortions were given, thus the locks on the doors. And downstairs in the large rectangular room, that was where the men who brought women to have an abortion would go and sit at the bar and have a drink And the big blank space on the wall was designed so they could show movies. Now, everybody knew that that's what this house was, which kind of gets us back to the O'Brien perspective, right? That these things have to become acceptable in the broader culture before they'll ever be enshrined in the law. And when the Supreme Court gets around to acting on these sorts of things, it's probably a fight that has been had already and already been decided. And lo and behold, that was actually true in Roe versus Wade. So it's strange how it came to be American constitutional law. And there's any number of perfectly good reasons to read the case and understand that it was decided, I think, somewhat flimsily on 14th Amendment grounds. So when you see somebody showing up for a confirmation hearing and people ask, senators ask, do you agree with the way that Roe versus Wade was decided? Almost everybody who's had legal training of any kind would look at it and say, well, no, clearly not. Politically, that is not the answer that any of them ever give. And you can see just how the pressures occupying these people who, as they sit for the most important job interview they'll ever have, as the pressures wear on them, they give strange and weird answers. And those strange and weird answers show up again and again and again after they get on the court. So whatever they say in their confirmation hearings is probably almost as a rule incorrect. But then they're left with other problems when they get to the court. How do they square whatever their opinion is with the broader cultural opinion? If, for example, and this is something that's going to come up in Planned Parenthood versus Casey in just a couple of minutes. If, for example, the Supreme Court decided in a case that gets brought to them next year that abortion rights in the United States really have been incorrectly applied and understood, and they all have to be rolled back to the point where not only is this a state issue where different states can decide different things, but no, let's go all the way on this and say what was legal yesterday will be illegal forevermore, that abortion will never be legal in the United States again. All right, hard to imagine that happening, but work with it as a thought experiment just for a moment. What would happen after the Supreme Court did this? Would the United States of America rise in one mind and say, well, I guess that settles it? Hard to imagine that being the case, isn't it? Easy to imagine would be a bunch of people in a bunch of different places saying something like, well, yeah, I don't think so. And that's what the court has to worry about. It has to worry about coming to good decisions, yes, but it really has to worry about coming to decisions that will be enforceable. So 16 years after Roe is decided, the state of Missouri comes up with a law, and we'll concern ourselves with the preamble of the law, which actually becomes important fantastically in a moment. The preamble of which goes, the life of each human being begins at conception, and unborn children have protectable interests in life, health, and well-being. So it's trying to give functionally constitutional rights to the unborn. The statute in question in Missouri tried to accomplish these things. It required Missouri state laws be interpreted to provide unborn children with rights equal to those enjoyed by other persons. So the unborn equal to the born, subject to limits imposed by the federal constitution and federal court rulings, which wouldn't amount to much if this first bit was even-handedly applied. Second, it prohibited government-employed doctors from aborting a fetus they believed to be viable. And this becomes some variant of what we would call now a late-term abortion, right? If a baby, a fetus, depending on your point of view, can continue to live outside of the protection of its host mother, well, then different rules have to apply. And then finally, it prohibits the use of state employees or facilities to perform or assist abortions, except where the mother's life is in danger. Well, that's actually something, isn't it, when you really think about it? And then this fourth bit, it prohibits the use of public funds, employees, or facilities to encourage or counsel a woman to have an abortion, except where her life was in danger. So not only can you not do this, you can't even sit a woman down and say, well, these are your options. How on earth is this conformable to the decision in Roe versus Wade? How do we end up looking at this statute thinking, I'm sure the Supreme Court is about to walk in and slice this to ribbons in order to keep us conformably within the standards set out in Roe versus Wade? And here, the Supreme Court obviously curtails abortion rights, obviously curtails it. So any evidence that you get in Roe versus Wade that a right to an abortion is somehow the kind of right that exists everywhere and always, that a woman might be pregnant and not want to be. Not anymore, because in this case, we get this. The court didn't bother considering the constitutionality of the preamble because it's not used to justify any abortion regulation otherwise invalid under Roe. So they just kick it out of sight. Second, the prohibitions on the use of public employees, facilities, and funds did not violate any of the court's previous abortion decisions, as no affirmative right to the use of state aid for non-therapeutic abortions existed in the first place. So go ahead, they said, roll them on back. And finally, provisions requiring testing for viability after 20 weeks of pregnancy were, in fact, according to the Supreme Court, constitutional. But those limiting abortions in the second trimester of pregnancy were unconstitutional. So all of a sudden, that trimester approach, which everybody is utterly convinced we still use, was tossed out for a 20-week dividing line, which in a 40-week pregnancy, it's not 9 months, it's really 40 weeks. Well, here you go. And isn't that interesting? Well, what's left of Roe versus Wade at the end of this case? And it's not exactly clear. The great fear on the part of many was that a future Supreme Court would take this as a stepping stone to get to the point where it could decide that American women would have no abortion rights whatsoever moving forward. The example that I gave earlier, where it seems to be the case that even if they decided that way, it might be impossible for them to get that holding enforced in any way, shape, or form. And this constitutional problem came to a head in 1992 with the case, Planned Parenthood versus Casey. And here is Sandra Day O'Connor, who was sitting on that court. The expectation was that this court, and don't you know, Sandra Day O'Connor gets cut out by the circle. That's kind of perfect in its own way, isn't it, when you start to think about all of these issues at once. The expectation was that this court would finally overturn Roe versus Wade in an overt, obvious way. And yet the result of this case that you know, having read it, was nothing of the kind. And it's very, very strange how this case gets decided until you realize that the Supreme Court is absolutely a political body and it's looking after its own interests every bit as much as the other two branches of the federal government do. This is some language from the middle of the decision that carried the day. It was a decision that a number of justices were on. This is a difficult decision to parse through, but at the most basic level, this bit of Supreme Court decision text that you see before you was how this case was ultimately decided. At the heart of liberty, the decision states, is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. It's known as the mystery segment, largely understood to be written by Anthony Kennedy. And the obvious question that people had was something like, what the hell is that? The heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. I honestly have no idea what that could possibly mean in the space where we're looking for constitutional jurisprudence. So what was the court's real concern? How does this text even make it into a decision? And once you realize that the court's real concern is its own legitimacy, the rest of this starts to fall into place. Is the court looking to decide every case perfectly in conformity to the Constitution, given what the respective justices know about the Constitution? And the answer to that question is, well, yeah, but not always, because its own legitimacy is really quite important. And the court admits in this case that it can't maintain its own legitimacy were it to vacillate in its decisions year after year. And this is always why in those same confirmation hearings, you hear about stare decisis, right? You let the decision stand, that it has to, previous decisions must inform new decisions. Put in the context of the race cases that we considered last week. This is why when Brown was decided, it was decided in such a way as not to invalidate Plessy on the merits. What was used instead? The Kenneth Clark Dahl test, which was called social science research. Well, we had learned some things between Plessy, which in the 19th century didn't really include much by way of social science, and Brown by 1953-54, at which point we've got some understanding of social science and the sorts of things that it shines a light on. And given that difference, the court said, we can change the opinion. We don't have to hold on to Plessy as doctrine because modern social science research has proved that incorrect. Now, in this case, what do we end up with in all of the abortion cases? We always end up with this idea that the central holding, and they speak of it, justices in their opinions, speak of the central holding in Roe often. It's always overtly upheld in the abortion cases, even as that holding is eroded from the edges much of the time. So we swipe away the trimester approach in Roe and replace it with the 20-week version. Is that not curtailing abortion rights in the United States? Well, of course it is. Of course it is. It takes one standard, throws it out, and offers another, a more stringent standard. But they can never bring themselves to undermining the case in its entirety. Why? Why would they? Is there something different? Something along the lines of that difference in scientific research and understanding that we got in Brown versus Board of Education so clearly? And there really isn't. There's no new facts available. There's just the same old argument that we always have. And given that, well, the Supreme Court has to concern itself with its own authority. And that authority would be undermined to whatever extent it vacillated in its decisions year over year. And here, if you really think about it, we're really all the way back, and we'll just pop up the Wikipedia here, we're all the way back to Alexander Hamilton, who in Federalist 78 laid it out quite clearly. The only power of the judicial branch is the power of judgment. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm, even for the efficacy of its judgments, because of the court's weakness. And we laughed at that the first time we heard it, and I think rightfully so. But as you think about it with a little more clarity, and as you unearth the sorts of cases that would convulse American society were they overturned, you start to see Hamilton's perspective coming into perfectly full view here. And you should be able to understand how the justices feel very hemmed in by the institutional impediments that they face. On the one hand, they've got a set of decisions that were made long before they rose to the bench. And on the other, they're powerless to enforce whatever rulings they come up with. So what's going to happen? And that's actually what keeps things kind of interesting. You find that you get this dance between the three branches of government. And it's always, and I mean always, about legitimacy and the possibility of problems underneath the decision that seems on its surface to be perfectly sensible. So when you think about these sorts of things, this is the expanded universe of concerns. Is the case simply about abortion rights? No, it's about a lot of different things. And when you can say that about almost every important case, and you can, it's very clear how you're going to end up getting incongruent results. What you expect is not necessarily around every corner. People fight about it all the time, but think about the pressure that the justices on the court are under, because the pressures that they face determine in no small part how they proceed. And on that happy note, we'll call it an end. I hope this was at least fruitful and not agitating. I know talking about abortion often is, but I think at the end, you kind of see why we have to. We'll see you all soon.